All right, welcome back. Okay, welcome back. First off, I understand your class on Wednesday of next week is canceled beforehand. If anyone has a work conflict, something else, email me. If there are 0 objections, and I mean 0, I am okay starting the class earlier. But if anyone has a work conflict, otherwise, I'll start it at the regular scheduled time. So if you let me know by Monday, today's Wednesday, let me know by Monday, and I will schedule a room accordingly. But I have no objection to starting early. I was kind of sad I won't see any trick-or-treaters. I actually have a house now, and I can't give up my constitutions that way if I'm at home. Yes.
Do you get candy with me?
Maybe. Well, you give candy and constitutions. But I have an entire box full of constitutions to hand out to the kids, and maybe you want to save the children of my neighborhood by keeping me in class late till 9:30. But okay. Although, what time does trick-or-treating stop? 7:30? Is that 8? When do people stop? I don't know. 9? 10?
It'll go late. You give out those constitutions. Be prepared to pick up a lot of stuff the next day.
Lots of eggs. Shh. Okay. Very good. My favorite was when Halloween was on a weekend. That was the best. Yeah. All right. But yeah, email me if anyone's objections, work or otherwise, and I'd be happy to reschedule the class. Start at 5:30 or 5:45, whatever you want. Okay. Questions. Questions from last class on affirmative action, Gruder, Gratz, Fisher, Bakke. Anything in your minds?
I have a question.
Yeah.
Okay, so you may have said this last time, but I'm not sure. These cases use the strict scrutiny and the different tests, and it kept going back to the economic liberty. And I think they mentioned, a couple of mentioned Caroline, the footnote 4. So I got a little confused because I remember last class you said that the rules are specific based on the type of case, like the due process, and then the equal protection. But then you look at it, sounds like they kept using them when there was a due process.
Well. So Caroline Products, right? The footnote 4. Mm-hmm. I tried to explain this at the time, and it's a tricky point, but it's not a specific rule. It's a way of looking at political processes. So, for example, today in Cleburne, right, it talks about footnote 4. In Frontiero, it discusses footnote 4. I think it came up in Bakke also a little bit, right? Maybe not in the part you read, but it was in there. So the general discussion of equal protection will invariably circle back to footnote 4, but not as a rule of decision, as sort of a guiding principle, if you want to call it that. Does that clear up things a little bit for you?
For that part, but then for the I can't remember which case. I guess probably I think I highlighted it in the book, but I distinctly remember they were sort of kind of giving an overview, like kind of over of the strict scrutiny, and then they were talking about it with both the economic liberty cases.
Which case you're talking about? I'm not sure. If it comes to you later, you can tell me. I want to answer your question, but I don't know what case you're talking about.
I just want to make sure I'm understanding when you said that they're.
If you find it and ask me after class, I'd be happy to give it to you, but I'm not clicking right now.
Okay.
If it comes to you, raise your hand later in our class, okay? All right, other questions? Yes, ma'am.
We briefly touched on the Freedmen's Bureau. Will that be something that will come from?
It can. Yeah. I'm sorry. We moved way too quickly at the end for my taste, but following, I'll just do a little lecture just so you have a little bit more on it.
We didn't hear her question.
Oh, the question about the Freedmen's Bureau Act. So in 1865, after the Civil War, we have the ratification of the 13th Amendment. And the ratification of the 13th Amendment said slavery shall not exist in the United States. But critically, under Section 2 of the 13th Amendment, Congress had the power to enforce that provision by appropriate legislation. And they quickly enacted 2 provisions of law. The first was the Civil Rights Act of 1866. We spent a lot of time talking about it. And the second was the Freedmen's Bureau Act. I think it was also 1866, but just check me on the year. And those are both statutes passed under Section 2 of the 13th Amendment. The Freedmen's Bureau Act in particular was designed to help, as the name suggests, the freedmen. It created a branch of the executive branch of Bureau to provide different services to the freedmen, help them obtain property, help them obtain training, help them obtain education. It was a fairly progressive program for the time. And at the time, the South was under Reconstruction, which was basically run by the Union Army. That's the only way to describe it. And it was designed to help incorporate the freedmen back into civil society. The reason why we put that excerpt at the end of your chapter is it's something that doesn't really come up in the affirmative action cases, but I think maybe should, insofar as it shows at the time of the framing of the 13th and 14th Amendments, there were proactive race-conscious measures designed to help the freedmen under the Congress's enforcement powers. All right, that's all I can do for now, without much more. But that help a little bit? Okay, thank you. All right, anything else before we get started? All right, so to date we've discussed the standards of strict scrutiny and the standards of the rational basis test. And up until this point, it was fairly straightforward. If you had a racial or religious or a national origin classification, you went to strict scrutiny. Everything else jumps off to rational basis land. But after today, it starts getting a little fuzzy. And the categories start to blur. When we get to sex discrimination, and then when we get to Cleburne, where things really start going in a different direction. So I want to start with a question, if I may, that will help bridge us from last class to this class. So here's your question. Again, I'm not just looking for you to say yes or no, why. I want you to be able to articulate why the answer is what it is. So here's your question. Men are required to register for the draft. I think all the guys in your 18, you did this at some point. Women are not. Does this regime violate the Equal Protection Clause? That's your question. True or false? Or yes or no, I'm sorry. Okay. Where did I drop off last time? Who's next? Who are you pointing to? Were you last?
I get the facts for that last case.
Thank you. Yeah, okay, Dana. All right, I'll call on you then, Dana. Okay. You guys deal with this outside of class, right? Dana. What do you think? What do you think the answer is here?
Well, I think I put yes.
Okay.
Because you're looking at it in regards to intermediate scrutiny test, since it's regarding sex.
Okay.
I guess quasi-suspect.
Okay.
And the test that we use is the government policy where the means substantially related to serving according government interests, and I think it is related, but I wouldn't consider it substantial because I think there are other ways that you could.
Okay, so Dan, it says like this. We have here a sex-based classification. She's correct. We know it's a quasi-suspect class. I'm cutting to the chase with Craig v. Boren, but we're cutting to the chase. It's quasi-suspect. And you give intermediate scrutiny. So we ask, is the means, in this case, a gender classification with the draft, substantially related to serve an important governmental interest? So Dan, just to start off, what is the governmental interest being served here?
Just getting, I guess in this case, men prepared if there's a war, just getting men ready.
Okay. National security, something like that?
Yes.
Okay. And the exclusion of women, Diana. You said it's related to that policy, but not substantially related. Just walk me through your thinking there. Just.
I didn't say, I don't think, because I think you mentioned something in the prior semester that it's kind of saying that women aren't up to the standard to serve in the army, which in that case I disagree with. So I think it's
Okay. Are you next, Marcus?
No, not next, but I think.
Who's next? I think you're next, actually.
Oh, am I?
Okay. So, Marcus, let me ask you this question. Until fairly recently, really recently, women could not serve in combat in the military. That's, I think, the last year or two, it's been changed, but pretty recently. So let's just say as a general starting premise that women can't serve in combat. Does that change the analysis here?
That they can't serve?
They cannot serve in combat. That's the policy. Let's just, again, I think it's been
Not by way of
changed.
their ability.
I'm sorry?
Not by way of their ability.
The policy is women can't serve in combat. That's the policy.
If it, what's the rationale behind it? Not that I agree with it, ladies. The rationale behind it is that women are inherently and physically inferior by nature. I mean, if the policy is that, maybe there's an argument. Or if it's, you know,
All right, let me try to summarize. Right? So until fairly recently, women were excluded from combat. Women were excluded from combat, and there are a couple reasons offered, right? So maybe one is physical ability, right? A second one might be if they're captured, there might be other types of risks that don't attend to men being captured. I don't need to discuss what those are. But if you have this policy, does the government then have to include women to be drafted if they will never serve in combat? In other words, is it necessary for the government to have this policy of equality if women would just be doing perhaps ancillary duties that are not necessary for combat? And the Supreme Court actually decided this case. It said that it was constitutional. The case called Roxer versus Goldberg, decided in the 1980s. I always spell it wrong. It's R-O-K-S-T-E-R or R-O-X. I can never, damn it. There are two Roxer cases, and I always confuse them. It's R-O-S-T-K-E-R v. Goldberg. R-O-S-T-K-E-R v. Goldberg. There's another case called Roxer, which was like a file sharing case. I was getting confused. And the court upheld it. And the simple reason why, the court said, is if women aren't eligible to serve in combat, then there is a good enough reason to exclude them from the draft. But the reason why I give this example is not to test you one way or the other, but to see what that means substantially. And I like what Deanna did a minute ago. She said, well, they're related, but it's not enough of a relationship, right? And the fit, we keep using the word fit, how strong that relationship has to be dictates the difference between a rational basis scrutiny, an intermediate scrutiny, and a strict scrutiny, right? That's how these three tests are divided up. All right? So, I mean, the answer here is the court said it does not violate the Equal Protection Clause. Although I question under current law, in light of the Virginia case from Justice Ginsburg, as well as the fact that now women are eligible for combat, I don't know that holding works anymore. It might have worked 30 years ago. I don't know if it works more. Yes, ma'am.
So that's what I was going to ask, right? So I was thinking, I actually say no. I agree with Marcus. Shocking, I know. But I was thinking along the lines of, if you think about the way that the court has historically, ruled about women, and in the cases that we've read, it's that women are supposed to be at home and have babies and can do that, you can come back, and that women are basically inferior to men. So if you and the Equal Protection Clause was around men, and so I looked at it from that perspective that says that if you're not equal to do everything else, then you go to war and I stay home. So I didn't think it violated based on previous court history. So that's what I was going to ask is, do you answer the question based on historical rulings or strict scrutiny all the time, or just kind of based on what era you might put the question or whatever?
Yeah, so to answer your question, whenever I give you a question, I'll give you a year. Right? That's how I frame my exam questions. And you'll make your judgment based on what year you're in. And you can even tell between 1972, 73, 74, 75, even in the 70s, the rules weren't quite static. Things moved around. And you get to the Virginia case in the 90s, the rule moves around a little bit more. And I think this rule might move around again next year or two after you guys graduate, but not that you care. This class keeps changing. Every year I teach, it's a little bit different. All right. So, any other questions on that? Yeah, Clay.
Your example. Okay, so the means would have been
Excluding women from the draft.
and defense would be.
Having a cohesive fighting force that can defend our nation or something of that effect.
Okay.
Yeah, Mia?
In quasi, the burden is on
My reading, and we'll get to this in a few minutes, as Virginia, the VMI case suggests, I think the burn's in the state. The burn's in the government. I mean, I don't know if that's how it was in the 70s, but at least after Virginia, the burden is on the government. I think even in Craig v. Boren, the burden's in the government as well.
That kind of confused me when we were reading it. Remember you said the burden would be on the person bringing the suit.
Usually it is, but in the context of gender, the court does a little bit something different. This is where students are getting very angry at me, right? It's very nice to have this picture of these 3 tiers of scrutiny, like a 3-layered cake, and they're very neat and simple, but they're not. They blur together. The court makes exceptions. They make carve-outs. They say they're doing one standard, and they're probably doing another standard. It's messy. And just you wait till we get to Justice Kennedy. Just you wait. He doesn't care about scrutiny at all. It makes no difference in whatsoever. Tiers of scrutiny are irrelevant. Fundamental rights don't matter. He never talks about anything but rational basis. It will drive you batty. So just buckle up and just go one step at a time. All right, so let's talk about the 14th Amendment, right? We did a fairly early gender case, which was Bradwell. Right? This was a case where the woman wanted to get admitted to the bar, and she brought a claim under the Privileges or Immunities Clause of the 14th Amendment. She did not bring a claim under equal protection. And I do have to stress that. The Equal Protection Clause was designed to talk about protection, protecting people from violence. It was never meant to serve as an anti-discrimination principle. That just wasn't its design. But under the last, 100 years or so of precedent, that's how equal protection is understood, so we're stuck with it. So if we take the Equal Protection Clause to be an anti-discrimination principle, it applies fairly broadly. It doesn't apply to citizens, it doesn't apply to men, it applies to persons, right? And it says that no person should be denied the equal protection of the law. Yet, we don't have any sense in the case law about classifications and why perhaps one came before the other. It's mostly a product of history. That in the civil rights era, most of the cases involved racial classifications. And only later did the courts start discussing sex-based classifications. They only came back in the 70s where they actually started thinking about this with a little bit more precision. And the shift towards sex-based classifications was driven in large part by now Justice, but then a lawyer and professor, Ruth Bader Ginsburg, who was head of the ACLU Women's Law Project. Ginsburg's biggest impact in the law, I think, was not as a judge, but as a lawyer. And it's difficult to understate this. I mean, she wasn't all her, but she had a lot of the arguments herself. I'm sorry? Oh, okay, yeah. And the strategy was very much mirrored on the NAACP Legal Defense Fund strategy. And it was designed to go incrementally, to find small cases that weren't that big, to try to get court rulings that would reflect favorably on more judicial protection of women's rights. And they chose a very specific type of case, one in which men were being harmed. That is important, right? They weren't going to court and saying, we need you to treat women better. They're going to court saying, we need to treat men better, right? It's almost counterintuitive. But the thinking from Ginsburg and others was this. It would be easier to persuade the justices, who were all guys, to be sympathetic to a guy being discriminated against than to be sympathetic to a girl being discriminated against. Think of Bradwell and the motherhood and the kitchen, all the other stuff, right? So they picked cases that specifically targeted laws that disfavored men. And invariably, these laws were built on stereotypes. And the stereotype, again, was that the man was the provider and the woman was the homekeeper, right? So the first case, Frontiero, fits into that dynamic very carefully. I think, Christy, you're next. You want to give me the facts, please, in Frontiero versus Richardson?
Sure. You have a wife who is a lieutenant in the Air Force.
Good.
And she is seeking to claim her husband as a dependent so that they can get higher living wages and insurance benefits, things like that. But she unfortunately was stopped because she didn't prove that her husband basically made less than half of the income of the household. Whereas if it were reversed, a man wouldn't have to prove that. They could simply claim their wife as a dependent.
Okay, so Kristen, just one more question. Why do you think the Air Force instituted this policy where if a wife was claiming these benefits, it was basically automatic, but if a husband was claiming these benefits, they had to go through all these hoops?
Well, because of discrimination, but that's like the cop-out answer. But I think it's just basically because they don't want the woman to be seen as the breadwinner. You want the man to maintain that patriarchal.
Well, you're very close, right? You're very close. But if you had to ask, let's say you were doing a deposition of the lawyer for the Air Force, right? Why do you have this policy? What do you think it would tell you? Just indulge me for a minute. More men in the Air Force? Sergio's next. You're deposing the lawyer for the Air Force, right? And you say, why do you have this policy? What do you think he's going to tell you?
It would be assumed that the wife would be dependent on the husband,
Yeah.
and they would save money by not giving the benefit, by not assuming the opposite.
By not assuming. Okay, give me a little bit more. Now you're on the right track, right? Tell me about this assumption. Why is that assumption important?
Because if they assume that the husband is going to have a job or provide for himself, then they wouldn't have to provide for him.
What's the risk, Sergio, of automatically giving money to a husband? What's the risk?
What's the risk?
Yeah. What's the risk of automatically giving money to the husband? Marcus?
Same argument for welfare, that they won't want to go out and work.
No, that's not it. Not it. Clay? What's the argument for automatically giving the money to the husband? Right? Why is that problematic? Of just giving the money to the husband no matter what, they don't have to prove anything. There's a reason. I'll come back to you, Mia.
Because it costs them money.
And what's the risk of giving to the husband automatically? It costs money. There's a risk. Danny? I'm sorry. Name tag was off. Sorry. Trisha, sorry. I was looking at an angle.
You're assuming they're double dipping.
Double dipping. Bingo. That's it. The presumption is the husband's working, and he's going to claim this automatic benefit. Now you see, right? They presume that the husband's working, so to make it automatic is going to be resulting in fraud, right? It will result in fraud if the husband can claim this money automatically. What's that noise? Is there a vacuum? Wow, that's loud. Right. You presume it's double dipping. I like the way you put that. Okay? Meanwhile, for the wife, you presume she's not working, and therefore there's no reason to prove it. She's not working. Of course she needs the spousal benefits, right? So again, it's based on a presumption. Now, again, to your question I gave to Sergio a minute ago, if you're the lawyer, you say that this is an administrative procedure to reduce fraud, right? That the Air Force only has so much time to investigate claims, and we'll use our resources more efficiently, right? We'll use our resources to target where fraud is more likely to occur. It's more likely to occur with husbands than with wives, so that's where we're going to focus our energy. We don't need to investigate all these women because we're just assuming that they are not employed. This is a fairly common argument in a rational basis scrutiny, right? That there's a problem, the government chooses a means to fix it. It's not perfect, but it helps them allocate their resources in a way they find more efficient. Think of Lee Optical, right? Where they restrict only eye doctors fitting lenses. What kind of problems is it trying to solve? Well, maybe there's sort of health condition, right, that we need to try to solve. Is it likely? No. But you can focus on one small problem and then deal with the rest of it later in a different law. So generally, under a rational basis review, the statute would probably be okay. Probably. Because the government says we need to focus where fraud is more likely to occur, and we decide it's more likely to occur with the husbands and the wives. And that's what we're doing. Okay. You don't have to agree with that, but that's the general rational basis approach on Lee Optical. Just that much we can agree on. All right? So Clay, why didn't that argument work here in Frontiero? Right? Why did that argument not pass muster?
They said that classifications based on sex are inherently suspect.
Ah, what difference does that make? Why does it make a difference if the classification on sex is inherently suspect?
Doesn't that mean strict scrutiny?
Yeah, and what does strict scrutiny mean?
It means the ends have to. It's just a.
What's the test for strict scrutiny, my friend? Check your notes. It's okay. Check your notes. That's fine.
The government policy is narrowly tailored to serve a compelling governmental interest.
Okay, very good. If in fact sex is a suspect classification, and then you apply strict scrutiny, then you do this test that Clay just gave us, right? You have to have narrow tailoring. Narrow tailoring, right? That means the solution, your means, have to fit perfectly your ends, or pretty damn near perfectly. It's not enough to solve part of the problem or say that, this might be a way to reduce fraud. You got to show this is really necessary. We need to use gender here. We need to use sex here because this is the only way we can achieve our goal. Right, Janice, how could the government achieve this goal of eliminating fraud without going through this classification? What could they just simply do? How could they eliminate fraud with that by putting a gender classification?
Well, they cannot allow it to be automatic. They can actually go through the process of
For men and women.
Investigating it for both. Yeah.
For men and women, and would that require hiring more employees?
Yeah, I mean, it wouldn't be as efficient.
Bingo. That's the key point, right? With strict scrutiny, you can police fraud. There's no problem. The government can stop fraud. But they do it without the classification, which means they inspect everyone's application. They hire more inspectors. They reallocate the resources to actually focus on fraud. Now, Mia, what happens if it turns out that fraud really isn't that big of a problem?
Then it is not necessary.
And if fraud is not really that big of a problem,
That compelling.
no, but if fraud's not really that big of a problem, what's the answer I gave to Sergio as a lawyer, right?
As for,
Right.
because of the empirical.
But what if the government says we're worried about fraud, and it turns out that fraud's really not that big of a problem?
Well, then it doesn't fit within the test because
It's what you call a pretext. You know what that means? Pretext, right? Pretext means the reason I gave to the lawyer is not the actual reason we have this policy. So with rational basis review, the government can come to court and make a reason up. They can just make it up. Say, yeah, you know what, we're really worried about fraud. We're about fraud. Is there any evidence of that? No, but we're about fraud. Is that the actual reason, or is that a reason that was manufactured for the course of the litigation? Understand? So with rational basis review, the government come in and just make up a reason out of whole cloth for purpose of the litigation. But with the heightened scrutiny, you need an actual reason that motivated the legislature, right? Not something that just came up and made up, but something that actually was their purpose. So if I had to guess, this rule was not created to reduce fraud, although that's probably a good reason for it. This rule was created based on the certain stereotypes that I think Kristen mentioned a few minutes ago. That women were the breadwinners. Women were the homemakers, and the men were the breadwinners, right? And that was the basis of this policy. But now it gets tricky, right? What if it's both? What if the history is, I'm making this up now, this is not what happened, let me just make this up for a minute. What if it turns out they said, you know what? We presume that women are going to be working at home, so they're less likely to be engaged in fraud. And we presume that men are going to be working, so they're more likely to engage in double dipping in fraud. What if it's both, right? They're working with a stereotype, and they have an interest in reducing fraud. That's where the scrutiny matters. If it's mixed, right, a mixed motivation case, under a rational basis or intermediate scrutiny, it probably will survive. Under strict scrutiny, it won't. That's why it's important here that Justice Brennan, who only had 4 votes, by the way, we'll get there in a minute, right? He only had 4 votes. Didn't count to 5 here. Justice Brennan got to 4, said strict scrutiny works. So when you are dealing with these equal protection cases, one thing to keep in mind is the reason the government giving the actual reason, or is it an excuse? Or is it a combination of both, right? Are there multiple reasons why the government wants to act? Maybe some good reasons, maybe some bad reasons. Okay? The upshot is none of this is going to matter, because once you get to the Virginia case, the distinction between intermediate and strict basically vanishes. It's a very, very subtle distinction, if any exists at all. I don't think it does. But at least in theory, with an intermediate scrutiny, when you have this sort of mixed motive case, the government probably should win. But that's not how it actually comes out in practice, right? In other words, with rational basis, you can just make crap up and you win. With intermediate, I think at least, you can have a mixed motivation. As long as you have some good reason mixed with bad reason, you probably win. And with strict scrutiny, you can't have any bad reason because you're going to smoke it out. But as the case law turns, intermediate and strict are virtually indistinguishable. Okay? All right, so that's the majority, or I'm sorry, that's the plurality in Frontiero, right? This is Justice Brennan, only had 4 votes. We call this a plurality. There was no 5-vote block, right? All the judges agreed this was unconstitutional, but they didn't agree why. Most of the judges said this is only a rational basis review, right? You only give this rational basis scrutiny. But Justice Brennan's plurality said, no, we give it strict scrutiny. And he explains that sex is much like race. It's innate. He says you're born with it. You can't change it. And there are deeply embedded stereotypes in our culture concerning sex discrimination. But his position only garnered 4 votes, so therefore there was no majority to hold out strict scrutiny. All right. So any questions on the Justice Brennan plurality opinion?
So, okay,
Yep, please.
The holding in this case.
Well, I don't want to say holding, just say the plurality, because
Okay, right, 'cause it
just be
was-
precise. There's no 5-vote block.
But it was they said it was under the Fifth Amendment.
What a good question, right? So which governmental entity are we talking about here, Janice?
We're talking about the federal government. I got that part, but the
Yeah.
part where so it was mixed with other equal protection cases, but they specifically talked about the procedural burden, here, because she would have to prove, whereas man would not have to prove. So I got that part, but then I remember prior to that, you had said that with under due process. It protects fundamental rights.
I know your confusion here. Okay, I get you. Bowling versus Sharp, my friend. Remember Bowling versus Sharp? This was the school desegregation case from D.C. The court held in Bowling that the Fifth Amendment's due process clause reverse incorporates the Equal Protection Clause of the 14th Amendment. That's what you were asking me due process. Now I understand your question. Everyone understand your point. I want to make sure everyone understands this, right? The Fifth Amendment controls the federal government. It does not have an Equal Protection Clause. But in Bowling against Sharp, that was a segregation case from D.C., the court held that there's reverse incorporation, that the Equal Protection Clause of the 14th Amendment goes back into the Fifth Amendment's due process clause. So this is Janice's question. It's a good question, right? The Fifth Amendment due process clause is both due process and equal protection. And let me tell you, it will confuse the heck out of you in some cases. Like we do a case called Windsor, which involves the Defense of Marriage Act. And Justice Kennedy says, yes, it violates the Fifth Amendment. Doesn't explain why. It's just Fifth Amendment. Drives me crazy. But that's why. We're not talking about Lochner here. We're not talking about fundamental rights here. We're not talking about any sort of due process liberty interest. It's equal protection through the federal government. That clear up your confusion from before?
Yes.
Okay, good. Now I know what you're saying. Kills me. I don't know what people are saying. Yeah, Mia.
Really quick question.
Please.
So administrative convenience, could that ever withstand strict scrutiny?
Not strict scrutiny. And apparently here, not intermediate either.
They just called it close scrutiny. They didn't say that it was.
The phrase intermediate,
Was this
yeah.
intermediate scrutiny or moderate scrutiny?
So Justice Brennan was a very influential justice for his day. We don't talk much about him anymore. He was very influential. His greatest talent, as he would often say, was to garner 5-vote majorities. Didn't really matter what the 5 votes said, but he got 5 votes, and that's all he cared about. And he would never exactly say what he's doing. He would sort of talk around it. Good. Yeah, I'll get there in a minute. He would sort of talk around it and then hope in a year or two he would get more votes for it and make it a solid lock. So he doesn't call it strict. But by calling it a suspect classification, the necessary implication is that it was strict scrutiny.
And then the second question was, is he saying that it wasn't necessary? That the fit was the problem, or that it wasn't a compelling?
Well, again, his opinions are very fluffy, right? He doesn't really give any analysis, if you notice. He simply says the important takeaway is that sex is a suspect classification, and therefore the fit is not close enough. But he doesn't say narrowly tailored, doesn't do that, doesn't go through the entire routine. And again, I don't think he had 5 votes to do that. He didn't have 4 votes to do it. He had 4 votes to this sort of wishy-washy middle thing. Now, the question, who's next? Quinn, I think you're next. Why do you think the court, at least at this point, was hesitant to make sex a suspect classification? Why do you think there was a hesitancy, to this day even, to render sex a suspect classification?
It could have been a timing thing.
What do you mean timing?
Not sure. Maybe they thought people could react a certain way.
Well, Quinn, let me ask you the question like this. What would the consequence be of treating sex as a suspect classification that renders strict scrutiny? What would the consequence be for that sort of legal order?
I imagine they'd think if it was a timing issue, they'd think the consequences would be kind of great.
But generally, can the government survive strict scrutiny?
The government.
Yeah, can the government impose racial classifications, for example?
Well, if it satisfies the test.
But that's my question. Generally, can you pass strict scrutiny? Can the government racial classification survive strict scrutiny? That's my question. No. Okay. So Vincent, the question is this: what would happen then if we then treat sex in the same category as race? What would the consequence be for legal challenges?
So it would be very difficult for the government to pass laws that are beneficial towards women.
Or that treat men and women differently.
Or exactly.
Exactly, right. Marcus?
Wouldn't it then be more fair for men in child custody cases?
Perhaps. I'll leave it there, right? He tried. But actually, there were a lot of these sort of gender cases where actually states had presumptions built into law saying that the presumption is a mother gets the kid. There are a lot of cases like these. And the ACLU actually challenged these, paradoxically, to establish rules saying these are unfair. Or there are cases that if there's a death of a parent or whatever, that the son gets whatever. Anyway, but yeah. But to go back to Vincent's answer a minute ago, right? If we give strict scrutiny to gender classifications, then that effectively does one of 2 things. It either renders all sex-based classifications unconstitutional, number 1, or 2, you have to water down strict scrutiny. You have to dilute it, right? And this is a point that Thomas raises in his dissents in Grutter and Gratz, that if we water down strict scrutiny, that might have lingering implications for the future. So you can either invalidate all sex classifications, which might even include bathrooms, dormitories, same-sex colleges, which was VMI, that's what happened. Or you water down strict scrutiny, and that might make it more possible to have a racial classification. So it's really easy to say, oh yeah, just go strict all the way, right? They made a calculus that it was not a good decision to do. So what they ultimately did was they called it intermediate, and they basically did strict scrutiny anyway. So it makes no difference, I think, in the end. But I want you to put your mind in the 70s of what was their calculus of not extending the strict classification to gender. Okay. So any questions on the plurality in Frontiero? Okay. So any questions? All right. So let's go to the next case. The next case is Craig against Boren. And actually, this is a photo, I think it was taken in 1996 on the 20th anniversary of Craig. And it shows Fred Gilbert, who was actually the lawyer for Oklahoma, Carolyn Whitener. She was the owner of the Honk and Holler grocery store. I love that name, right? The Honk and Holler grocery store. Why was it? I don't know why it was called that. But the setup of this case was similar to Frontiero. It was actually brought by the owner of a liquor store who wanted to sell beer to men and women alike. And she was unable to because of the law in effect in Oklahoma. So, Michelle, you want to walk us through the facts, please, and Craig v. Boren?
Yes, so there were 2 sections of the Oklahoma statute that prohibited sale of 3.2% beer to males under the age of 21 and females under the age of 18.
Very good.
And so Craig was a male that was between age 18 and 21, and he was joined by Appellant Whitner, who was the licensed vendor of 3.2% beer.
Mm-hmm.
And so they brought the case challenging the Oklahoma statute to the district court, the Western District Court of Oklahoma.
Mm-hmm.
And the district court found that the government's objective of traffic safety was important government objective, and
Mhm.
that the statistics introduced established that gender-based distinction was substantially related to achieving that goal.
Very good, thank you. By the way, I think I've just figured out why it's called a honk and holler. You honk your car and you scream what you need. Is that it? It's a drive-through. I've been teaching this case for years. That just occurred to me. Is that it? Does that make sense? You honk your thing and then you holler what you want to order, because it looks like there are stalls, right? You can drive your car right up to the window.
They would run out and take it to their car.
Have you seen a grocery like this before?
No, I'm from Oklahoma, but no.
I've never. So in New York, in Texas, they have drive-through liquor stores. That's a new one for me. I didn't got this. Okay, but I think that's it, right? Honk and holler. Huh. It just hit me like a bolt of lightning. I never actually thought about the name. Okay. Anyway, Michelle, that's very good. Thank you so much. So that's a very good discussion of the facts. I know I totally changed the topic, but yeah, very good. Thank you, Michelle. So Oklahoma, again, imposed a benefit to women and imposed a disability on men, right? Women were allowed to obtain light beer, which is what, 3.2%. I've never had it, but you can have this light beer when you're 18, and guys were allowed to get it when they were 21. Now, we did a case involving alcohol before. That was South Dakota v. Dole, right? And that was a case where South Dakota didn't want to drop the drinking age, raise the drinking age to 21 with respect to the federal funding. Here we have a slightly related issue. Why did Oklahoma say that they were able to give this differential treatment, that women had their ability to buy beer at 18 and men had at 21? Why was this regime in effect?
Because they based on the statistical evidence that show 0.18% of females were arrested compared to 2% of males being arrested.
Okay, very good. So they show that there's a higher incidence of underage guys getting arrested for drinking than for underage girls getting arrested for drinking. So at once we see a difference between Frontiero and Craig, right? In Frontiero, the government said we need administrative efficiency, right? We need to have, we need to allocate our resources to prevent fraud. It wasn't very rigorous. You know, it was basically, yeah, I think we need this. In contrast with Craig, they actually have some numbers. I know lawyers and law students hate math, and that's why you went to law school, you hate math. But they have some sort of statistics, right? So Lun, why are these statistics not enough for the court to uphold the differential treatment of men and women in this case? Why are the statistics not enough?
Not since they use the intermediate scrutiny, so it's not substantially enough related to that.
But why? But if the statistics show that men are more likely to get arrested for drinking underage than women, why is that not enough of a relationship?
Because
for the vendor to restrict the purchase, and the insurance data is more for those DUI.
Ah. So we have here a problem, right? We have here a problem. The statistics concern driving under the influence, right? Drunk driving, DUI. The law is not prohibiting drunk driving. The law is prohibiting the purchase of alcohol. So you might say, well, maybe you can have a law that says if you're a female and you're DUI, there's one penalty. And if you're male and you're DUI, there's another penalty, right? Make a bigger fine for men driving under the influence. Maybe you could do that. That'd be more narrowly tailored. So Kanisha, why does the government not have that burden? Or maybe they do, right? How precise of a measure do they have to have in order to address drunk driving? And everyone agrees drunk driving is a problem, right? I think no one's going to dispute that. But how precise do they have to be in order to limit drunk driving?
Can I ask you a question first?
Yeah.
So I was gonna ask, what's the difference with, well, I guess maybe I know the difference. When I was reading this, I thought about the fact that insurance is more expensive for males versus females.
It is.
So is that kind of like a way around, because it's not a specific thing. It doesn't specifically say, there's nothing written that I've ever seen that says that insurance will charge you more for men or women. They just do it.
They do.
Right? So is that
But
kind of like...
why do you think, Kanisha, let me ask you a question. Why do you think insurance companies charge lower premiums to teenage girls than to teenage boys?
Because we drive better.
Statistically, yeah.
Do you know that to be the case?
The numbers say so.
Is every woman a better driver than every guy?
For the most part, yeah.
Oh. But that's a stereotype, ain't it?
It is. That's correct. It is definitely.
But wait a minute. I'll come back in a minute, right? Wait a minute. This happens every time I teach this case, invariably sometimes, right?
I'm being like the justices. I'm like hypocritical.
You can be whoever you want, right? We have a stereotype based on numbers. I think Kanisha's correct. I haven't looked at the numbers carefully, but female teenagers probably are less likely to do dumb stuff in a car than male teenagers. At least in my experience, that's probably true. Maybe not. I don't know. But insurance is not set by the government, right? Insurance companies aren't required to comply with the 14th Amendment. The government is. So there are certain things that perhaps private entities can do, generalizations, stereotypes, that the government can't do, right? So, Jason, right? What stereotype does the majority think Oklahoma's law is based on? What's the stereotype? And I think Justice Brennan makes this point very directly.
That
why is it more likely that why is it more likely that a guy's arrested for DUI than a girl's arrested for DUI?
That they tend to drink more than the women.
Well, his attack is on the arrest rate, right? Why does Justice Brennan think there's a difference in the arrest rate between men and female for DUI? Delbert?
Does he say because the police officer dropping the females off at home?
Yeah, he tells a story which might be true, I don't know. But he says it's more likely that if a guy is busted for DUI, is arrested, and if a girl is busted for DUI, the officer drives her home and takes her to her parents. Is that true or not? I don't know. But he seems to think that there's a stereotype, that the law embeds a stereotype that men are less responsible as drivers than are women. Mia, was your hand up?
Yes. Did you ask what the relationship had to be, the fit?
I don't think I got there yet.
Oh, okay, I thought that was the question.
I'm getting there eventually. I'll get there eventually, right? So I think Delbert's correct, right? Justice Brennan says that the Oklahoma law is based on a stereotype, which might be backed up by numbers. Kanisha gives us numbers, right? I think she's right. There might be numbers which support a rule that you can have different liquor laws for men and women. And it's a matter of charging insurance premiums that might be rational. But here, it doesn't meet the constitutional scrutiny. And to this point that Justice Brennan says, well, you know, we had 4 votes for strict scrutiny a couple of years ago. We don't have them now. We don't have strict scrutiny now. So instead, we're going to apply something else. And he doesn't really label it, right? Doesn't really call it anything. Only Justice Powell sort of says, yeah, we're doing something else here. We're doing something funny. And this is peak Brennan, right? He gives this test, you know, towards the very end of his opinion. And I'll just read you this test. He says, in fact, when it is further recognized that Oklahoma statute prohibits only the selling of 3.2% beer to young males and not their drinking the beverage once acquired, the relationship between gender and traffic safety becomes far too tenuous. That's the fit, right? To satisfy Reed's requirement that the gender-based difference be substantially related to the achievement of the statutory objective. That's your test, right? He buries it like in this little sentence that if you read it quickly, you miss it. He did this all the time, Brendan. It drives me nuts. Teaching-wise, makes it hard to teach, but he buries his test in there. So it requires not narrowly tailored, not rationally related, but substantially related. Right? So again, rational basis requires a rational or a reasonable relationship. This middle tier intermediate scrutiny, whatever you want to call it, requires substantial relationship. And strict scrutiny requires narrowly tailored. And he says here you can't rely on the statistics. He says these are dubious statistics, right? You can't rely on statistics here, right? This is a law that's targeted not at the drinking of alcohol or the driving and drinking, but on the sale. It's too far attenuated. Now, Drew, thank you, sorry. Drew, let me ask you a question. Let's say Oklahoma changed their statute, and they said if a guy is pulled over for DUI, he gets a $100 fine. And if a woman's pulled over for DUI, she gets a $50 fine. I'm just making up numbers, but you know, there's a difference, right? Do you think Justice Brennan will be okay with that statute? And again, it's based on the same statistics that men are more likely to have DUIs. You have to have bigger deterrents, right? Bigger deterrents for men drinking and driving.
I think not, because it's not a substantial relation. And again, he wouldn't take the use of statistics to...
So then, can there ever be a gender-based classification for Justice Brennan? What would cut it? What would make that permissible?
I'm not sure. It seems like it would be pretty tough to get past it if you can't use statistics.
Yeah, and I think he's right. I think Drew makes a good point. Once you say that even if the government comes forward with statistics, that is not enough, then it's going to be very hard to ever satisfy this middle tier scrutiny. Look at the VMI case we'll do in a couple minutes, right? Where they have all this evidence about the adversarial method, none of it matters. And this is what I want to impart on you. Once you go above rational basis review, the court feels confident in knocking down your evidence. Right? Even if you come forward with evidence, the court will knock it down, saying, oh, that's not good enough. That's too attenuated. That's not substantially related enough, right? And when judges are in the business of knocking down evidence, then it's hard to win. You know, think of Lochner, right? The government said we need an 80-hour, or was a 60-hour-a-week rule because baking is a dangerous profession. And the court says, it's not dangerous, right? We don't think baking is dangerous. Who gets to make those judgment calls about policy? The legislature or the courts? I don't know. All right. So the upshot is, by the time you get to Craig v. Boren, the court adopts heightened scrutiny for sex-based classifications. Now they become known as quasi-suspect or almost suspect. Justice Powell, I think, has a decency to say, well, this is new middle tier. I don't like middle tier. That name didn't stick, middle tier. The name that stuck was intermediate scrutiny. That's the name that stuck. Justice Stevens was very consistent on this point. He said that there's no scrutiny. There's only one equal protection clause. And I think he's probably right about that. The entire notion of scrutiny is fictional. It's made up. There's nothing in the Constitution that says this class goes this way. It's all made up. It's all a construct for courts to interpret things. Okay. So any other questions in the majority of the concurring opinions? I'll do Rehnquist in a minute. Yeah, Mia?
The Reed case that they cited
Yeah.
him in, did he accurately?
No.
Okay.
Not. I mean, I shouldn't say no. Reed did not apply strict scrutiny. Reed did not apply intermediate scrutiny, but he kind of suggested it did. Right? Brennan was very loose with his language deliberately, knowing he could probably cite in the future in some other case. I think Reed is one of those cases.
Did he write Reed?
Someone Google that. I don't remember. I'm guessing he did. He wrote a lot of opinions. He wrote a lot of opinions back in the day. He doesn't. Very few of his cases are in case books. He's going to be, I think, the way. I can't quite compare who he is going to be like, but his opinions were very important for the time, not because they were well reasoned, because he got 5 votes, and those opinions don't stand the test of time, right?
Don't tell Taylor that.
Don't tell who?
Taylor.
Oh, she likes Justice Brennan.
She loves him.
Justice Berger. Oh well, he is.
Majority for Reed.
Was it Berger? Yeah, but it was a rational basis opinion, right? I don't think Reed was much more than that. Yeah, I mean, Reed was 71 or 72. I think it was just rational basis. 71. Yeah. I mean, look, I don't need to knock Justice Berger. He was very influential for his time, but the kind of opinions that are in your book are the opinions that stand the test of time, right? When you read a Holmes opinion or a Harlan opinion or a Brandeis opinion, right, or Cardozo or Robert Jackson, these opinions will be in books for hundreds of years. Brennan, whatever. They won't be. They won't be because they're there because they got 5 votes for no other reason. I think Kennedy will have a lot of those opinions also. I'll be teaching this class for the next 50 years, and maybe I'll be right or wrong, but some opinions will stand the test of time. This can't, because even people who agree with this saying, what is this? This isn't. I don't know what this is. Anyway. All right. Any other questions on the majority or the concurrence? All right. Rehnquist, who at this point I think was the most conservative member of the court, wrote a dissent. And he had 2 objections. And I want to focus on the first one first. He seems to be of the opinion that men should not be the people suing about this stuff, right? He seems to be the opinion that men don't need this. And this actually reminds me of Justice Holmes's draft dissent in Buchanan v. Worley. Remember, he was annoyed that it was a white guy bringing the lawsuit that he couldn't buy the house from the black person. Remember that one? He wrote this draft dissent. He said, this is not for us, basically. And Rehnquist, I think, is having a similar thing. He's saying, wait a minute, this is not for the majority, it's for the minority. And that didn't stick around. That went away, and I think the court ever went back to that. His bigger opposition is for this new middle tier, which he calls intermediate. I don't know if Rehnquist made the name up, but at least I think he made it well established. But Rehnquist criticizes it about applying any sort of heightened scrutiny. He would apply rational basis review. And this was a standard we used in Williamson against Lee Optical. This was the glasses case. And he says it's not required to make members of the government come forward with a PhD in statistics, right? To have these advanced models to justify why the laws exist. It's not for the courts to second guess and scrutinize so carefully how the state arranges its social policies. And under rational basis, this law survives by a wide margin. Okay. All right, are there any questions on Frontiero or Craig against Boren? Yeah, Yarn? I'm sorry?
Does he just think they just come up with whatever they want? Because he says the court conclusion that a law which treats Northwest rather than may serve important governmental objectives and may be substantially related to the achievement of its duties apparently comes out of thin air. So does he think that they just come up, like they just basically were like, we don't know how to fit this, so we're just going to do what we want?
Well, where did Rehnquist get that test from? I'm sorry, where did Brennan get the test from?
He got it from Reed?
And where did Reed get it from? You didn't assign Reed. So the short answer, yeah, no, it's an unfair question, right? The short answer to Yaron's question is all the tiers of scrutiny are made up.
Okay.
right? This is Justice Stevens' point. I think Stevens makes this point quite well. This entire idea of saying narrow tailoring, substantial relationship, and rational related, those are all judicial tests that the court developed to handle different types of cases. And one point that's not well understood is the Supreme Court doesn't only announce tests for itself. It announces tests for the lower courts, right? And scrutiny serves as something of a sorting mechanism, or if you think of like Harry Potter, the sorting hat, right? Depending which hat you're in Hogwarts or Slytherin or whatever, right? A Gryffindor, right? Wherever you wind up probably ends up your outcome. If you're able to get into the strict scrutiny hat, you probably are going to win. And if you're in the rational basis test, you're probably going to lose. So the court established these tiers, not just for its own use, but also to guide the lower courts. But these tests are all judicial creations. And that's not to say that they're right or wrong. They're creations. And what Rehnquist is saying is we have this long body of case law saying anything that's not suspect is rational basis, right? That's what we should stick. And he doesn't like these newfangled tests. And once we get to Cleburne, you start seeing that this neat three-layered cake starts becoming like, pudding with everything's all over the place. Yeah, Mia?
So the rational basis is the minimum rationality.
It's called different things, but yeah, Lee optical is sometimes referred to as minimum rationality. Minimum rationality, okay? So long as there's a reason why this could be rational, that's enough. Rehnquist would not even require statistics. I think it's overkill for him. The fact they have statistics is just icing on the cake for him. Any other questions on honk and holler? I just figured it out. I've been looking at this picture for years. It never occurred to me. I'm so... It's something new every day. I always learn something new. Anything else? All right. Fast forward 20-something years, right? There were a number of sex discrimination cases in the 80s that we don't put in your book anymore. So again, cases fade in and out of the book. Every time making additions, like what cases you leave, what cases you cut. I think Frontier is probably going to stick around for a while. Craig Boren will stick around, but we had some cases from the 80s that just fell out. The next case we'll do is from Virginia from 1996. I think, Kyle, are you next?
Sir.
Kyle, you want to give me the facts, please, in Virginia?
Sure. So there's this, or there was, I guess, this male-only Virginia.
That's true. That's true. By the way, Justice Ginsburg spoke at VMI a year or two ago. I think it wasn't their graduation, but she spoke there. So it was like a big deal. But anyway, go on.
So it's co-ed now, I assume?
It's still in effect, yeah. The school's open.
All right. So anyways, VMI, they used to only allow men. And they're like a military school, so their whole goal is to produce citizen soldiers.
Citizen soldiers, yeah.
Which is basically like good citizens who are ready to be called into service.
Okay.
And in order to do that, they have this kind of basic training style environment where basically when you first get there, you're treated like dirt and you have no privacy.
Nope.
And you have to do like physical training and whatnot. And then they gradually move you up into like decent status, right?
Yeah.
So that you'll have a bond with the people that formerly tormented you.
Okay then.
So that's their method of instruction. And there's a female that wants to attend the school, but obviously she's not allowed because she's female. And VMI's position is that they should be allowed to discriminate, which by the way is run by the state. And the U.S. government is bringing a lawsuit against Virginia, alleging discrimination in violation of the Equal Protection Clause of the 14th Amendment. So this woman is not allowed in. The U.S. Attorney General sues the state of Virginia. Virginia defends its law, saying that due to the nature of their school, they have to discriminate based on sex. And the court does not agree. They strike it down.
Okay, thank you. So we have here a case with a state institution. And they've been operating as a single-sex, all-male academy for 100-something years. And they insist that they have a very important reason why they need the single-sex instruction for the adversative method, where, to use your phrase, they treat you like dirt, right? they push you to your physical limits. Does anyone ever go to military academy here?
College basketball, it's all the same.
The same? Wait, what was that? Okay. I would flunk out of here in about 5 seconds. I would not even make it past the welcome door. Would not work. But for some people, they want to do it. So the question here is, if there's a woman, a female student, who can meet the standards of admission, can the school exclude her simply because of her sex? All right, Ross, so walk me through the court's analysis here.
So they began to talk about how it was, they first started talking about the history of women, how women started being allowed to vote, things like that.
Uh-huh.
And then saying how Justice Ginsburg said about how it was exceedingly persuasive.
Oh, you're jumping way too far ahead, right? Let's just start a little bit more basic, right? What was Virginia's first effort to give women some opportunity?
They created like a separate campus at a women's university.
Yeah, very good.
That pretty much they tried to copy the adversative program.
Very good.
They said that there were disparities in it, like the SAT score was lower for them to enter. They had less PhD faculty, lower salaries, and then that Virginia went to the court just kind of say that was our remedy for.
Very good. So this litigation went on for a number of years, went on forever. And in the first round of the litigation, the Fourth Circuit Court of Appeals said, well, this is unconstitutional, but you can create a women-only facility, and that would pass muster. So they create this other thing called the Virginia Women's Institute for Leadership, VWIL. I always get the acronym mixed up. The VWIL at Mary Baldwin College, which is an all-girls college in Virginia. But it wasn't an equal facility, and it quite literally was separate but equal. It made Justice Ginsburg's job a lot easier. I think it would have been easier not to have this, but it helped her opinion out. All right. So now, Jessica, what then was the reason why Justice Ginsburg found that this policy was invalid?
She used the same test, just like you were saying, the exceedingly persuasive justification, and she said that Virginia didn't have an exceedingly persuasive reason for the separation.
Well, Jessica, just start here. Did it have any reason?
I mean, it did.
Okay, so start there. What was the reason Virginia gave to have a male-only academy?
Well, for that,
But specifically, why did they need a male-only academy for the adversative method?
because that was the method of how they educated the men that were going there.
Now, is that the only method they could use to do the adversative method?
No, that's just the method that they chose. They said was the best, most successful.
So here comes a question, right? Do you have to force the university to change their method? Or is it enough to say that your method is unconstitutional, so choose something else? Right? In other words, does the state have a strong interest in keeping the method as it exists? Ginsburg's opinion acknowledges very quietly that there must be some changes made to the program. She does this very subtly. So for example, changing facilities, right? Sleeping accommodations, bathrooms, right? As this rule establishes now, there's no privacy, right? Everyone's in one big room. And Ginsburg basically says, well, there might be situations where you have certain accommodations that have to be changed to deal with the fact that now there are men and women together. Does that change the adversative method? Probably. Yeah, it does. Does it matter? She says no. So the bottom line of this case is you can't do your exact plan if it results in this gender discrimination, right? You lack an exceedingly persuasive justification to keep this iteration of the adversative method in effect. In other words, choose a different method. She cites the fact that the other military academies at West Point, at Annapolis, Air Force Academy, they had all integrated women some years earlier. So the upshot of the VMI decision is the court saying that you may not be able to keep it exactly the same as it was, but because you lack an exceedingly persuasive justification, you got to change. And this is no different than the Craig v. Boren or Frontiero, right? You had some regime that maybe worked well for you. Maybe it reduced fraud. Maybe it reduced drunk driving on the streets, right? But you can't choose it. By the way, the upshot of Craig v. Boren, I forgot to mention, is now they raised drinking age for everyone, right? They didn't drop it, right? So now no one can buy beer at 18. It's one of these weird cases where the upshot of a decision is everyone's worse off for it. Right? With VMI, everyone gets in. That's actually a win-win, I suppose. But in the drinking case, it's a lose-lose. Everyone can't drink at 18. Well, it depends how you define lose. If you want safer roads, it's probably a good thing. But anyway, yeah.
Where did she get exceedingly persuasive?
Where did she get exceedingly persuasive?
The thin air?
Where did Justice Brennan get substantial relation? Look, these are tests that
She actually put it in quotes
she
in the book.
she did.
It's in the dissent where she got it from.
Yeah. It's,
Is that where she pulled it from?
where do you have it handy?
I thought they were just like,
Let me see.
no, I thought like she got
I
it
mean,
from
look,
somewhere and then
even if she quoted it from somewhere, it was made up there, right? I don't recall.
Well, it was only a one quote. It wasn't like the double quote.
Yeah,
Well,
so we don't have the site, but we have the state justification. Actually, no, that's just.
No, I didn't think there
where
was.
I got it from.
So again, I don't want this to be too cynical, because God, we've been cynical the last couple of weeks. But the courts adopt standards, right? And they do this not just for their own benefit, but for the benefit of the lower courts. When you say that the justification must be exceedingly persuasive, what that does is it brings intermediate scrutiny real close to where strict is.
Okay, that's what
It brings it real close.
that's what I was at. 'Cause
There's not much of it. Yeah, there's not much of a gap
Okay.
between strict scrutiny and intermediate after the Virginia case. Not much of a gap at all.
Was, okay, so
Please,
it
yeah.
sort of seemed like it was intentional to actually bring the next, bring another case
Close.
a higher
Higher.
standard, but not
Call it that.
exactly the same.
Yeah. And if you're sensing this now, you'll see this more in Cleburne.
Yeah.
You'll see it in Romer for next class. And when we get to the gay rights case, you see it very strongly, right? The court doesn't really use the scrutinies anymore, right? The upshot is if the court thinks that some sort of classification is bad, they will apply what's effectively strict scrutiny, but they'll call it different things. Exceedingly persuasive, rational basis plus, what Marshall call it? Middle level, next level, and he has a name for it, I can't remember the name. But they call it different things. Yeah, Tricia.
They said exceedingly persuasive justification is from Hogan.
Hogan was another case from the 80s. Yeah.
They cited that one like two sentences after.
Well, this is in Scalia's dissent. He said the court chose to prefers the phrase exceedingly persuasive justification from Hogan.
Yeah, and Hogan was a case, it was a case involving a women's college from the 1980s, which again is a case you don't have in your book anymore. But yeah, I mean, it's not that, it wasn't made up here, but might be made up somewhere else. So eventually, there's a patient zero where a phrase comes from. I'll give you an example. Like when we do the abortion cases in 2 weeks, there's a phrase called undue burden, right? That's our test now, right? A law is unconstitutional if it imposes an undue burden on the right to abortion. Where did undue burden come from? It came from some opinion in the 80s that was run by 3 or 4 people, and then now they adopt it later. And where did that come from? Well, it came from somewhere else. And maybe a lower court used it, right? So these phrases, they germinate, and then eventually they get 5 votes. Thank you for checking that, Tricia. Appreciate that.
The one in that case comes from Kirchberg versus Fenster.
I don't even know that one. Which case is that? Is that a Supreme Court case?
Yes, from 1981.
And then where does that one come from?
Let's see.
Keep going, keep going.
So you said that though, right? You said that a lot of times you'll see in the concurring opinions or the censor so that there will be a test or a term or something, and then later on,
Yeah.
the court will go back and adopt that. So that's
Yeah, there's always a patient zero, right? It always starts somewhere where someone had an original thought, and then enough keeps citing, and then it gets 5 votes. And when it gets 5 votes, now it's law. Right?
In this 1979 case.
What was that one called?
Personnel Administrators of Massachusetts versus Feeney.
And I'm sure that's from somewhere else, right?
I can't tell you. I'll tell you later.
Keep going, yeah. But you see my drift, right? Where you have this language that doesn't really have 5 votes and eventually gets 5 votes. Or it's maybe used in different contexts. But that Supreme Court decision making is like, to use a phrase, like an onion, right? There are lots of layers, Shrek, right? There are lots of onions, and they keep peeling back, and eventually you find someone who made it up at some point in human history.
I think that is the patient zero.
Is that the patient zero? The Feeney case? Okay. Aha, it's not in quotes. Very good. Thank you. I've never tracked that down, but I'm grateful for that. Thank you. And sometimes it comes from a lower court, where they'll borrow a phrase from a lower court judge. That's occasion to case as well. It eventually goes back to Holmes. It always goes back to Holmes, maybe. All right. Where am I? Okay. So, yeah, so Ginsburg adopts this exceedingly persuasive justification. So it tweaks intermediate scrutiny in a way that, in my mind at least, it's almost indistinguishable from strict scrutiny. There's not much of a difference, right? Under the exceedingly persuasive standard, it's going to be really hard for the government to have a sex-based classification. Really tough. Really tough. Perhaps one of the only things that Justice Ginsburg acknowledges are privacy-based issues with respect to bathrooms and the like, and that's still an issue that's being litigated as we speak. Now, someone always asks, Josh, what about sexual orientation? We'll get there. The court doesn't ever actually address that in terms of scrutiny. Justice Kennedy doesn't like scrutiny, but that's not done here. Okay. All right. So, any other questions on the majority in VMI? Who's next? Jesse, walk me through Justice Scalia. Oh, by the way, Thomas recused here because his son actually attended VMI. That's why the vote was 7-1. Me, was that a hand?
Yes. So on the remedial side of it.
Oh, okay. Yeah, good. I didn't mention that. Go ahead.
She said that the remedy had to be shaped to place the class that was unconstitutionally denied the opportunity or advantage in a position they would be in absent the discrimination. So is that because they have the 3 options, admit the women, establish a parallel institution, or abandon it at all? So if it's a parallel institution then it has to be, I mean, because the way she said it, some women would get in. So if some women would get into a parallel institution, it'd be a really small institution the way they described it.
Well, yeah. Yeah, I mean, Ginsburg effectively says you have to find a way to admit women and accommodate them, right? Now, this is an issue that's litigated quite a bit with respect to physical standards. This comes up a lot. So, for example, firefighters, right? To be a firefighter, there are physical fitness tests, which, my God, I can't pass, right? But you have to carry a pack of a certain weight up a certain number of stairs in full gear with the smoke protection, right? That is not easy. That's not easy. I'm sorry?
It's also under a time constraint.
And you're timed, yeah. And you have a lot of districts around the country where there basically are no women who pass the exam. Maybe it's not enough. Take it, and then the question becomes, you lower the standards, give them more time, right? This also comes up in Marines and other high-level units where the physical fitness are tough. SEALs, for example, right? So the question is, are you obligated to give the same physical fitness test, or does lowering the test itself break the law? Because now having different tests and it's unequal, then a man can complain, why does she get 5 minutes, I get 4 minutes? So this is a very fraught area of litigation. Yeah, Sam?
I'm still a part-time firefighter since not to the weekend. A lot of departments now don't even have a time, so like our department doesn't even have a time control. Just if you can complete the activity, then you're okay.
Okay.
So, if there's a balance, it should be a balance, right? Because I would not want to ever be in a fire.
It takes too longer.
Shh, guys, just one at a time. Let her talk, please. Let her talk.
So as I listen to my sister was a captain. She's a chief of HPD. My brother's captain. and they still have the time and all that stuff, right? I would not want to be somewhere where they didn't, because I'm gonna need you to get me out of the burning building, and you need to be able to do that quickly. You're not gonna have a lot of time. So it's like, it would seem to me that there are some places where some areas where you need to balance that and use a little bit of common sense that says there needs to be, there needs to be some kind of test that says that you have to pass it. And there are women that are in the fire, in at least Houston Fire Department, several. And if you can get somebody out, more power to you. I'm not gonna try out for it, but I don't think you should lower the standard for things that have to do with people's lives, because now you're trying to be equal protection, because now you're not equally protecting the victim.
Sam, go ahead.
Oh, well, one way that we can try to combat that was the issue that we talked about, was even like in our lives, right? If I was stuck in a fire and I had to rely on somebody that didn't have the right training to come save me, we put each other's lives in the hand. When I go in with somebody, if she is a woman and she cannot drag me out, then what? If I'm risking my life for no reason, if something. So now they have, so like one of the tests, right? You have to drag a dummy that's 150 pounds. You have to drag it so far of a distance.
And drag? I'm sorry. Are you dragging people? Is that? Oh my God. So, am I screwed? Am I just gonna be all dragged up? Oh God.
You'll get dragged out. You're probably unconscious. You're alive. You're unconscious.
It won't matter. I'll be all banged up. It won't matter. So you're literally dragging the body. Is that right? Oh God.
Through the fire.
You can't put me over your shoulder. No, I'm just messing. Mia. Oh God, I'm done.
Just to bring that back, wouldn't that be the important governmental interest that would outweigh?
Yes. Yeah. So if saving people from fire in X number of minutes is really, really important,
that's compelling.
then perhaps having this time test is the most narrowly tailored way of accomplishing that goal.
That was exactly the point I just made.
You're welcome. Thank you. All right.
Well, in terms of that, though, that would be like a compelling one. But here we're just looking at if it's an important.
I mean, does the state have an interest in having an elite military academy at all? I mean, this is Thomas's point. Does Michigan have an interest in having elite law school at all? Probably not. But it depends what level of scrutiny you're applying. All right, Scalia, Jesse, you've been waiting patiently. Walk me through Justice Scalia's dissent, please. There's a solo dissent here. Yeah, I know. Okay. That's okay. That's okay. Give you a little break.
So, he basically said that it wasn't about the exclusion, it was about getting women to go into the academy, and that the academy, or whatever it was, the BMI, the whole point of it was to have that
Adversative, yeah.
To help for the men, and that if you put the women in, it's going to change all that. And that the scrutiny that the majority is applying is very indistinguishable. It's very similar to
Yeah, very good, very good. Okay, thank you. So Scalia is upset here. He's usually upset, yeah. He's upset here because he thinks the court is basically, he says, going through the motions of balancing. And he explains that this is not the sort of intermediate scrutiny that was around before. Indeed, he rejects the entire notion of scrutiny as something that the court made up. And he says there's a long tradition of single-sex education in colleges and elsewhere, and that now this decision throws all that into jeopardy. He also notes that invariably they're going to have to water down their program. And perhaps if they needed that sort of lack of privacy in order to have this adversative method, they can only accomplish that if women are admitted. Okay. So any other questions on the Scalia dissent? Yeah, Drew.
So does BMI do
They admit women.
Do they have like a separate?
They have separate dormitories. They have separate changing facilities. They have separate bathrooms. So it can't be entirely the same because the class has to be separated in certain components. So most of the activities are together, but in some categories they're separate. So I mean, it's not the same. It's probably a large part the same, but not the same. The court makes a big fuss about the fact that other military academies have figured a way of doing this, which invariably means changing your routines. I think that's probably what happened. And here's a picture of some of the first female cadets who graduated from VMI. By the way, I love this. Yeah, I wish I could find a better picture. This is the only picture I could find.
I feel bad for that girl.
I know. I wanted a picture for the first graduating class, and this is the one they have. It was from the Virginia Pilot newspaper, whatever. I think she's mocking someone. Is that a hook 'em horns? I can't tell where your hands are. Anyway, I love this picture, and I often note this. Even if you vigorously disagree, which none of us do, we all agree in this class on everything, right? Even if you vigorously disagree on legal issues, you can still be friends and still be civil and still be respectful to your peers. And Ginsburg and Scalia were always on opposite sides of cases, but in real life they were very dear friends. And they traveled around the world together. They were in operas together. They did all these really cool things. And here's this picture I just love. It was Scalia and Ginsburg riding an elephant together. They went to India on some trip. Anyway, I put that in your books. I'd like to. Yeah? You like the picture? No. I like it. It's okay. All right. Well, I will not ride an elephant. I think it looks very dangerous, but okay. Okay. Any questions on VMI? Any question on VMI? All right. So the next case is something of an odd case. Cleburne versus Cleburne Living Center. It's from Texas. We have a lot of Texas cases, don't we? It sure seems that way. Dana, you want to give me the facts, please, in Cleburne?
Yes, so this is about permit for a group home for, this is not my word, eventually retirement.
Yeah, and this word's still used in a lot of death penalty cases. When Randy and I did the video for this case, we were unsure how to quite do it because I don't like that phrase either very much. Yeah, but the opinion in the word, the word, it's a challenge because the word actually used in the case is mentally retarded. So we put it, I think we said quote unquote the first time to make it clear, but you can use whatever word you're comfortable with. But yeah, so you have a group home, right? A group home for mentally handicapped individuals, right? The reason why these people have to live in a group home is that they're generally not self-sustainable. They can't live on their own, and they need to live somewhere. All right, so Dana, go on.
So, the city denied the permit. They were pursuant to the zoning ordinance. The home, it would house 13 of these men and women, and they would be under constant supervision.
Okay.
And then when it got to the Fifth Circuit, they deemed, the mentally retarded as a quasi-suspect classification.
Okay. And what's the consequence then of calling them quasi-suspect?
You get a heightened level of scrutiny.
Yeah, you get intermediate scrutiny. Okay. Now, what's the argument, Glynis? What's the argument that these individuals are a quasi-suspect class? Why would they be quasi-suspect?
Well, they say that that they look at like the legislative response throughout, and that they're making like rules or laws to like support this group of people. And
but as a general matter, right? How does the court decide whether a certain classification is non-suspect, quasi-suspect, or suspect? Right? How does the court make that determination?
I guess like, well, So like if you're looking at suspect, they said like when it came to race, like they were born, it was something that you couldn't.
Immutable, right? You
And
can't be
then-
changed. Okay.
Whereas like when they talk about like mentally handicapped or whatever, this is like a very large and diverse group, and there's different levels and different ranges, and so it isn't I mean the term like black and white, like you're just.
So if it's about what you're born with, then why is sex not a suspect classification? If that's the test. I'm sorry, my back is you, I'm sorry. If the test is it's immutable, you're born with it, then why is sex not a suspect classification? Is sex any different than race in that regard? So what you're seeing here, right, is the tests used to decide if it's a suspect or non-suspect are fairly flexible, shall we say, right? They're not, I don't even like calling them tests, right? But Marquis, let me ask you this question, please. What's the argument that the people in this home were quasi-suspect, right? Why would they perhaps be treated in a heightened review?
Well, the court talked about the legislative process that they represented. They also talked about that they weren't politically powerless, and which that didn't merit a heightened protection.
Well, but so where is this business of political powerfulness coming from? Where's this coming from?
Well,
What's patient zero for that discussion?
I'm confused on the question.
Where? Fair enough. Where do we discuss before? Where did the citation start from about political powerlessness? Where does this come from? What case is like the origin?
Caroline Products.
Bingo.
Yeah.
Footnote 4, right? What did footnote 4 say about this?
They're talking about political powerless and that it didn't merit heightened protection as a discrete and insular.
Oh, okay, there we go.
I don't know the word.
Yeah, very good, very good. Okay, that's what I was looking for. Thank you. So, the court's framework for identifying suspect versus quasi-suspect classes builds in part on footnote 4 of Caroline Products. It's not a one-to-one, but it builds on it, right? So the lower court here found that mentally handicapped individuals are politically powerless, right? They generally can't vote, although I have an uncle who lives in one of these homes, and every 4 years they take him to vote. He can't read, he can't write, but apparently they take him to go vote. And I'm like, wow, you vote? He's like, yeah. I'm sorry, he voted for, but he voted. And they basically tell him who to vote for. I was like, you voted? You know, I was actually somewhat troubled by that because he can't possibly know what he's doing, but he said he voted. It's in New York. There's no, you don't. And I think they go in the booth with him also, and they put the thing for him. But it's New York, and I think they have him backing local candidates as machines, right? That's how he's in Brooklyn. But yeah, he was like, yeah. I was like, I voted for Hillary. I'm like, what, you voted? And then he's like, yeah. I'm like, why? He's like, I don't. They told me to vote for. I was like, oh, Yvette. But anyway, yeah.
I literally witnessed this Monday early.
No way.
This older lady brought her grandson, who was like obviously like mentally like not intellectually on the same level. Like, well, I'm not that intellectually high, but whatever.
None of us are.
But anyway, so she was like talking to him, and she's like, well, when you get up to the table, like, what do you tell the lady? And he was like, straight Republican ballot.
Wow.
And I was just kind of like, all right. Like, I didn't know.
I didn't know this happens either. It's wrong. I don't like it.
Yeah, I didn't like it either. And I was like, I wouldn't want to take away somebody's rights, but I'm like, that should kind of make you look at the spectrum, right, of like who can and
Well, I suppose imposing a literacy test might not be a good idea either.
No, not that. No, that's what I'm saying.
Right.
I don't want to take away any rights.
Right. So policing that would I think be even worse than the. So yeah. Yeah. You have to make an X on your name. That's all you have to do. But yeah, my Uncle Jerry is very bright. He can't read a word. But he very nice guy. He's almost 80 now. But he was like, yeah, I voted for Hillary. I'm like, you voted? Anyway, okay. Meanwhile, he memorized the subway maps. Remarkable guy. His mother taught him at a young age to know all the subways. He was a courier for almost 50 years. Worked for an investment banking firm. He would deliver stuff around. He knew every subway in New York how to get from point A to point B. Remarkable. Can't read a word, but he knew the subway map. So. Yeah, you do what you can. But anyway, going back to footnote 4 of Caroline Products, right? The thinking here is, are these people politically powerless? And I think Marquis said this a minute ago. Court says they're not. right? That these people have access to the political process. Apparently they can vote. I don't know, right? They're the grandparents take them in to vote with them, right? There's literally a bus and they bring them to go vote all together. He can't really walk. He has a walker, but anyway. Okay. But they're not a, is that a hand? Yeah.
What's the difference between, sex and race? Is something they're both something that you're born with.
Okay.
So since you can now technically change your sex, would it? That seems to me that it would never actually fall. It really would never be strict scrutiny.
Do you change your sex or do you change your gender?
Well, whichever one.
It's not what.
No, because I don't. Some people,
Yeah, it's not.
You don't mark F anymore. You mark M. So whichever.
Well, that's gender, isn't it?
So you change your gender.
So yeah, let me bring this back for a minute. So this is an area of law that's very much in flux, right? And if I screw this up, just correct me, right? But there is understanding to be a difference between sex and gender, right? That sex can refer to biological body parts, penis or vagina, right? Biological stuff. Whereas gender is something else. It's something that you can assign on your own accord. Now, I don't need to get into debate on whether you agree with this or not. I really don't care. But to the extent that you have sex as an immutable characteristic, but gender is not, that could actually perhaps have a different tier of scrutiny depending what you're asserting. And a lot of the cases now involving gender identity discrimination in bathrooms and the like is not premised on your sex, but on your gender. Now, the statutes all, or at least most of the statutes, say sex discrimination, right? If you actually read Title VII, it says sex and not gender. And there's actually a lot of litigation now is, can the phrase sex include the concept of gender identity? And this is going to be at the Supreme Court probably this year or next. It's a live issue now, and I don't want to prejudge it. But this is a very active area of litigation. And just one more point, is sexual orientation immutable? Are you born with it? Or is it fluid? Can you change it? Again, different people might tell you different things about how they understand it. It's fluidity. I mean, there's a lot of difficulty with the immutable characteristic. And one of the aspects you'll see in the Lawrence v. Texas case is about whether it's about conduct that is engaging in a sexual act versus your status, which would be sexual orientation. And the court doesn't quite ever give a clear answer on this. And a lot of it is much more about being in love and the like. And you'll read this when we get to the Lawrence case. But to finish your question, this is a live issue of litigation, and I'm not sure how this one's going to wind up. All right, any questions on that? Hope I didn't botch that too badly. I tried. All right. Yeah.
So, I guess hypothetically, a statute that discriminates on the basis of gender, and you want to know whether or not the legal framework that applies to sex discrimination applies to gender discrimination, right? So to me, it seems that any sort of discrimination against a gender is going to be relative to the assigned sex or to the born sex, right? So if you're discriminating against a transgender person, you're doing so because they're acting like a woman when in actuality their sex is male. So is it not at bottom also sex?
So you said a word there, because of, right? So let me give you a little bit more history, right? The civil rights laws just say you can't discriminate because of sex, right? Can a man bring a lawsuit saying he's being sexually harassed by another man? So there's some cases saying that they can. That even though perhaps you might think the purpose of the statute is to prevent man-on-woman sexual harassment, there are cases saying you can have it where it's a man sexually harassing another man. What if there's another case where a boss says, I like to hire a woman for this job because I think that they're better attention to detail, just making something up, right? Well, that's a case where the woman's actually gaining an advantage, but it's premised on a stereotype. And the courts have held that even positive stereotypes are discrimination because of sex. I encourage you at some point to take a class in employment discrimination law. Very important class because you will all be working some point and you'll all be exposed to various acts of discrimination in the workplace. Let me tell you something. Employment discrimination is statutory. It's not constitutional. So it's a lot different than all this 14th Amendment stuff. Yeah, Marcus?
I've been discriminating for the past 2 weeks. I'm hiring a nanny. And there's no way in hell I'm hiring a man.
Okay, so I'll address that. Believe it or not, not at one time, believe it or not, discrimination laws don't usually apply to small employers. And I don't mean short, but I mean like single person, right? I mean, so if you want to take in a boarder, right, someone to live in your X room or your basement, you can exclude people on the basis of their race. You can exclude boarders based on their gender. Now, if you have more than, I think, 4 or 5 units, I don't remember the exact number, you can't. Yeah?
It's 4 units.
4 units, yeah.
And you have to reside in one of the 4 units. And you cannot be a licensed real estate agent. Or you immediately, if you're a licensed agent,
Are you an agent?
held to the fair housing laws.
Are you perfect. I knew someone would know that. Yeah. So there are specific laws that basically let you discriminate as long as you do it in small quantities, right? That if you have a small enough business, for example, Title VII, which is the anti-discrimination law, checking this, but I think it doesn't apply to businesses with fewer than 10 employees. So if you have a business with fewer than 10 employees, you can discriminate based on race. Federal, not states are different. So for example, there was the Masterpiece Cake Shop case last year. The bakery had only, I think, 4 or 5 employees. It was small. But under Colorado law, all businesses are bound by, not just small ones. So this varies wildly. But even under federal law, we say discrimination and eradicating is compelling interest. But if you're a small enough employer or a small enough renter, you can get away with stuff. So Marcus can go hire a female nanny for his kid. All right. I don't know where the hell I was.
Caroline product.
Yeah. My goodness. Lucian's been just dreading me calling him for 15 minutes now, right? So, okay, so Lucian, why does the court here say, just to bring us back, that the mentally disabled people in this case are not a suspect class? Oh, no. We forgot what you said. She said it correct, but we bring you back. So just say it again.
The class was adequately represented in the legislative
process. Okay, so very good. So because the class was adequately represented, they're not suspect. Therefore, what's the appropriate scrutiny level, Lucian?
The rational.
Okay, rational basis. So usually I tell you guys, right, when there's a when there's a non-suspect classification and rational basis review applies, the government wins, right? The burden is on the individual, in this case the group home, to explain why the law is irrational. And if you apply the Williamson versus Lee optical standard, the government wins. Easy. Show me what happens in this case.
In this case, the court says that they are not a quasi-suspect class.
They are not.
They do rule that it was discriminatory based on the fact that they were subjugating.
The government loses. How can the government lose on a rational basis? How'd they screw this up? Man, if you're a government lawyer and you have a rational basis case, you can just phone it in, make crap up.
But it wasn't legitimate. The reason for them discriminating against the group home was not legitimate.
But does that matter in a rational basis if the reasons are real or not?
No, but the court has held in this case that they decided.
Okay, so here's the important point, right? Usually in a rational basis world, you can make crap up, right? You can just make arguments up. You don't have to give real evidence. You can say, well, you know what? We're afraid that people who don't get their eyes examined every year might have a disease. Is that a real threat? I don't know. I'll give you another example. Louisiana regulates florists, right? To become a florist, you have to pass a licensing exam. We have to actually arrange flowers. And who judges this licensing exam? Other florists. So basically, your competitors decide whether your arrangements are aesthetically pleasing enough to become a florist, right? Now, I'm not a florist, but it's a racket, right? It's protecting the florist from competition. So there was a trial where they asked the government official, why do you have this law about protecting florists? And he said, well, we're afraid that we might have infected dirt. That if someone's arranging flowers, they might cut their finger, and they might bleed in the little soil, and then there might be infection, and then it's garbage, right? It's not real. But under rational basis, like, oh, that's fine. Infected dirt, that's good. Yeah, that's fine, okay. Sounds reasonable. But here, that's not what's going on. This is not the optical rational basis review. Instead, the city, Cleburne, gives reasons, right? Justin, what are some of the reasons the city gives for why they have this, this exclusionary policy for the group home? They give a number of reasons.
Let me look at my notes.
Okay.
It seems like I remember that it had to do with emergency situations, maybe?
I don't know what you mean.
I know the court reason that they were discriminating against them because of other dwellings and lodging houses and fraternities and sororities and all these other hospitals weren't being charged their zoning permits. They were.
All right.
I don't really remember exactly why.
Okay, so what are the reasons the government gave for why they had this policy?
Like I said, that the council was concerned with the negative attitude of the majority of property owners located within 200 feet of the facility, as well as with the fears of elderly residents of the neighborhood.
What were they afraid of, Sahar? What were they afraid that the members of this group home were going to do? Austin? What were they afraid of, the city? Why are they trying to exclude these people from this community?
I don't know, maybe they thought it would make the city look bad, or that area seem, not as good, or.
Why? What were they afraid of?
They may have been concerned about, unsubstantiated stigma.
Ah, okay, give me a little bit more. Now you're on the right track. What were they afraid of? These individuals, right? What were they afraid these individuals were going to do?
Well, lady mentioned negative attitudes or fears.
Yeah,
So
yeah.
that could, they might have been concerned about their citizens.
Okay, yeah, okay. Brooke, what were they afraid of? Yeah, okay, good. Why were they afraid of putting this home near a school? That's. Okay. No, not the students may harass the occupants. All the way around. There was a fear that people might be dangerous.
The kids might be dangerous, right? Not the people. They made it seem like they were trying to protect them.
Yeah, let me take a step back here, right? Let me just take a step back right here. There's often a fear of the unknown, right? And that these people who perhaps don't have their full mental faculties might behave in unpredictable fashions. And if they're near students, maybe the kids will pick on them. Maybe they'll harass the students, right? If they're, one second. But that reason doesn't stand up to scrutiny, because I think they even know that the school has a number of handicapped students in the building, right? Mia?
I was just going to say, the government, the court didn't come out and say this, but do you think that they thought that was just pretext, that they were saying
Yes.
oh, the kids might be dangerous? That's just saying oh, we're passing this law to protect those people.
Yeah, let me give you an example. Did I tell you about the methadone clinic story? I just went in property. So when I was clerking, we had a case where a group wanted to open a methadone clinic. You know what this is? It's a treatment for people with opiates, right? And this was back in the mid 2000s before the opiate thing really blew up. But this was in Pennsylvania where it was going on. People didn't really know about it much. And they announced we want to open up an opiate clinic, right? And the city says, no, we can't do this. And they passed a law saying that you can't build a methadone clinic within 500 feet of a school, church, playground, etc. Let me tell you something. If you look at a map of any city, and you draw a 500-foot circle around every school, playground, church, there's nowhere to go, right? You can't go anywhere. In fact, you have cases with these sex offenders, right? Registered sex offenders. You can't live within 500 feet of this. You can't live anywhere. There's nowhere for you to go. They have to live under bridges, you know, and on off-ramps and highways, right? There's nowhere to go. So in my case, the methadone clinic actually said, okay, we found a place by the industrial district, right? There's no homes or anything nearby. So you know what the city does? There was this little strip of grass in front of the clinic, and they designated a park.
Oh my gosh.
And I actually worked on this case, and the judge found a violation of equal protection along lines similar to Cleburne, right? But the key point here is they gave lots of reasons why they don't want this near parks, and they made a little piece of grass a park, saying that's BS, right? That's pretext, used the phrase used a moment ago. That's not the real reason why you're doing this. So the sort of scrutiny they do here, whatever you want to call it, is what's called smoking out. What does that mean, right? Where you try to see, are the reasons asserted the actual reasons the government's acting? And they go through one at a time, the negative attitude, the floodplain, right? Concern about the size and the people. And they say, well, you gave me this reason, but not the real reason, right? Because you let other people build houses of similar size here. And you let other groups build in this floodplain, right? And all these reasons suggest that you're not actually giving me the real reason. And say the real reason you're doing this is you have a fear or some sort of irrational prejudice against the mentally handicapped individuals. Right? Yeah.
So in this case, since normally rational basis scrutiny is what, like, that's what they were trying to use, why did they scrutinize?
Well, this is Justice Marshall's concurring opinion, right? I think Sam is next. Sam, what does Justice Marshall say here, right? What's his insight in this case?
Justice Stevens concurring or Justice Marshall?
Let's do Marshall. All right, what's Justice Marshall's insight here? Does Marshall think that they're applying the Lee-optical traditional rational basis here? No. Does that bother him? Does it bother him? And the reason why it bothers him is not what you expect. It's a little bit unorthodox, right? He's not saying, yeah, we should just uphold the racial. I'm sorry, we should uphold the decision of the zoning board. He's upset, right, Cassandra? Why is Marshall upset here?
He says that they should have done a better job investigating and articulating facts.
Good. Why? Why is Marshall upset at the way the majority wrote their opinion? He agrees with the outcome, right? They all agree this is unconstitutional. But why is Marshall upset?
He also said that they erred in applying the rational basis.
Aaron?
Is it because he says that the burden was not on the city to prove that it wasn't, like, the burden is supposed to be, because it's rational basis, the burden was on the actual group to prove that.
But is Marshall troubled by that? Because again, he agrees that things unconstitutional, right? What's bothering him? What's in his craw? Like, Carrie?
Was it that they were using a heightened scrutiny as opposed to what it is that they're...
And what's the risk of calling it rational basis but applying something more rigorous? Why is that a risk, Carrie? We're going to make it all the way around today. We've done that in a while.
Would that kind of change the way in the future how you see certain things?
Yeah.
And now you're all confused.
Yeah, Danny, so what's the risk by calling it rational basis by doing something a little bit different? What's the risk there?
It's going to be harder to apply.
What case does he cite? It's everyone's favorite boogeyman, right? Lochner, right? Why is he screaming about Lochner here? What's his concern about Lochnerism? It always comes up. They always have Lochner. The poor baker just wanted to work a few more hours.
He says that as a matter of substantive policy, the government is free to move in any direction or to change direction.
All right. Tricia, what happens if the courts start scrutinizing things carefully into rational basis review? What does that lead to?
You could have floodgate litigation.
Yeah. Yeah.
They're not protected. Like if they actually start applying rational basis to this group of people, then
Yeah.
they're not protected. So you need to classify them correctly.
Yeah, so here's Marshall's concern, right? If you're applying what you call rational basis review in a very strict manner, then you can sneak this into other contexts, right? This is actually Scalia's concern in reverse, right? By watering down strict scrutiny or by beefing up rational basis scrutiny, you let litigants play with the facts. And perhaps there are other classes that are non-suspect, and judges will closely scrutinize those relations. And what Marshall's worried about is economic stuff. He's worried that we'll start closely, narrowly scrutinizing economic regulations, and that brings us back to Lochnerism. So you say, let's be honest what we're doing, call this group quasi-suspect, and give them intermediate scrutiny or something of heightened scrutiny. But he says, what's the opposite of watering down? Don't water up, right, rational basis review. Okay? And Marshall, I think, had an insight. He saw something that wasn't obvious, right? The majority didn't grapple with the fact they were doing something else. And the court never actually explained what it's doing. This is what drives law students bananas, right? They don't say what they're doing. In our reading for next week, the Romer versus Evans case from 1996, the court applies also this sort of rational basis review with bite. And that's what we sometimes call it. You call it rational basis plus, rational basis with bite. It's a little bit stronger. So, you have your rational basis, you have a rational basis with bite, you have your intermediate scrutiny, you have your exceedingly persuasive intermediate scrutiny, I can't reach, and then you have strict scrutiny, right? So instead of having like 3 categories, maybe have like 6 or 7, depending how you count. And the bottom line is this entire doctrine's a mess and it doesn't really matter anymore. But you can see here, our case by case, we make an exception when you carve stuff out, when you water stuff down, it basically destroys the entire structure. Not that there was ever a structure in the first place, but it waters it down. Yeah, Kyle.
Yes, sir. So if we go back to the concurring opinion by Stevens, it talks about how he basically was never convinced by the 2-tiered or 3-tiered structure.
Nope.
But there's a sentence in here that I wanted to ask you about because he says, in the last paragraph, I cannot believe that a rational member of this disadvantaged class could ever approve of the discriminatory classification. So is that a test ever? Does that have any relevance whatsoever whether the person being discriminated against would approve of the policy or could approve of the policy?
I think what he's trying to say is, had these people had access to political channels, they would never have approved it. And the fact that they couldn't is why the policy went forward.
But that's not a test that any other case applies.
No. All right, so let me wrap things up. We have about 2 minutes left. So we're in a weird space now, right? We spent all these weeks talking about racial classification and strict scrutiny, and things seem to have more or less a form to them, a substance. But now we suddenly jump to gender, and things start going, all over the place. It gets worse next week. We start doing what is often called substantive due process. And this is where the court recognizes so-called fundamental rights in the liberty clause of the due process clause. And if you think classifying one group as suspect and this group as quasi-suspect, if you think that's wishy-washy, wait till the court starts identifying rights out of wherever they identify them from. Okay, we'll leave it there. Any other questions? All right, I'll see you all on Monday. Have a good evening. And again, if anyone has a conflict for starting class earlier next Wednesday, let me know.